5 seconds to go. Start. If it is said that, during the police investigation I had deposed that on the next day, I came to know over phone that my daughter, the margin accused, had killed my granddaughter Farhana, and that thereafter I came to Preambalpur and saw my granddaughter who was dead, and that the accused had ran away, they are all incorrect. Stop. If it is said that, during the police investigation I had deposed that, as the accused could not act as per whims and fancies at Preambalpur, the accused had killed her child, it is incorrect. Stop. It is incorrect to state that as the accused is my daughter, I am adducing false evidence. Stop. Para. In her examination under section 313 of the Code of Criminal Procedure, 1973, the appellant denied all the allegations made against her as false. Stop. Para. With the aforesaid status of record, the trial court heard the parties and proceeded to decide the matter by way of its judgment and order dated 15th October 2009. Stop. Para. The trial court held that although PW1 to PW3 were related witnesses, but, PW4 and PW5 were independent witnesses who had seen the child and the accused appellant together, and there was no necessity for them to depose against the appellant. Stop. The trial court also held that the testimony of PW1 could not be discarded merely because of minor contradictions, given that she might not have been able to remember certain details on account of her age and other factors. Stop. The trial court also referred to the statement of PW6, the hostile witness, who admitted the fact that the appellant was arrested at the bus stand, and held that the appellant had not fulfilled the burden of proving alibi, since there were two, the evidentiary value of the prosecution case, however, the latter would not adversely affect the case of the prosecution. Stop. Para. In the case of Hirji Bhai Supra, this court has explained that concurrent findings of fact cannot be reopened in an appeal by special leave unless shown to be based on no evidence or inadmissible evidence, or being perverse or suffering from disregard of some vital piece of evidence. Stop. In that case, the finding of guilt concurrently recorded by the trial court and the High Court was challenged mainly on the ground of minor discrepancies in the evidence, for which, this court emphasized that excessive importance cannot be attached to such minor discrepancies. Stop. This court explained the reasons, including that a witness cannot be expected to possess a photographic memory, a witness is likely to be overtaken by events, particularly of anticipated occurrence, the powers of observation differ from person to person, by and large people cannot accurately recall the conversations or the sequence of events, and a witness, howsoever truthful, is liable to be overawed by the court atmosphere and piercing cross-examination, etc. Stop. The following passage from this decision could be usefully extracted thus, para. Their evidence has been considered to be worthy of acceptance. Stop. It is a pure finding of fact recorded by the Sessions Court and affirmed by the High Court. Stop.